Clerk will call the roll.
Chair Louderback,
Here.
Representative Moody,
Present.
Representative Bowers,
Here.
Representative Little, Representative Money.
Here.
Quorum's present.
Quorum is present. As a reminder, anyone present wishing to testify before the committee, please register at the kiosk located in the hallways behind the hearing rooms. If you require assistance in registering or testifying, please get with the staff. Due to the number of bills on our agenda and to accommodate all who wish to testify, there will be a hard limit of 2 minutes per witness during the public testimony period. Please keep your marks within that time frame. With that, we will begin. Chair lays out House Bill 4414. We're going to do 2593? Okay. You put me on 44.
Go ahead.
2593.
We got switch.
Do what?
Can you tell them everyone where we do House
The House bill we're going to lay out, House Bill 2593, and recognizes Representative Metcalf Chairman Metcalf to explain the bill.
Good morning, Mr. Chairman, members. Current Texas law reflects that children, the elderly, and disabled in our community are at a higher risk of experiencing exploitation, and there is an increased likelihood that they are unable to protect themselves from harm. As such, certain crimes committed against these vulnerable members of our communities have a higher punishment range upon conviction. For example, assault against a child, elderly, or disabled person is punished as a felony compared to the misdemeanor punish range if committed against an adult who is not elderly nor disabled. House Bill 2593 makes punishment range for indecent assault against the elderly or disabled individuals consistent with the idea that physical harm against this vulnerable population should be punished at a higher level. Specifically, House Bill 2593 increases the penalty range for indecent assault against the elderly or disabled individuals from a misdemeanor to a second-degree felony. This bill seeks to ensure that individuals who commit indecent assault against the elderly or disabled individuals are prosecuted to the same extent as other criminal actors. Members, House Bill 2593 strengthens law enforcement's ability to protect vulnerable individuals in our communities. Thank you, Mr. Chairman, members. I believe we do have one resource witness that can answer any technical questions.
Members, are there any questions for Representative Metcalf? Seeing none, Chair will move on to witness testimony.
Thank you, Mr. Chairman, members.
The chair calls Nancy Hebert. You get it right?
That's right.
Good morning.
Thank you for being here today. We show you registered as Nancy Hebert, and you represent who?
I'm with the Montgomery County District Attorney's Office in Conroe, Texas.
And you're testifying on for or against?
I am in support of House Bill 2593.
Hang on just a second. So we only have Assistant District Attorney, so can I get permission to say Montgomery County Assistant District?
Do we have your permission to say that you're with Montgomery County District Attorney's Office?
Yes, Your Honor.
And is she also
And do you represent yourself?
And yes, I do. And
Okay.
as the Montgomery County District Attorney's Office.
Thank you. You may proceed.
Thank you, Your Honor. My name, Nancy Hebert. I'm a prosecutor with the Montgomery County District Attorney's Office. I've been there for nearly 22 years. I work for the elected official, District Attorney Brett Ligon, board certified in criminal law, and a chief prosecutor over financial crimes, including elder abuse. And I am testifying in support of House Bill 2593. There are three reasons why this bill is so important. The first one is the greater protection to vulnerable people. There's numerous examples that we could give of instances where someone could be touched in a wheelchair or elderly, and then under the old law, it would just be a Class C misdemeanor. Under this law, it gives greater protection for that. It also brings consistency to indecency, that is the rights and protections afforded to children, to our disabled and elderly. So it enhances the punishment range for them. And the third reason I can tell you is someone by the name of Mrs. B. It's a case I have currently pending. She's 85 years old. She'll be 86 on Sunday. And she was touched while she was going to a doctor's appointment. And she feels and has expressed to me many occasions that she feels that she was taken advantage of because of her age. And so this offense and this bill would bring it in line with the other offenses that protect our elderly and disabled as well as our children. Any questions? I'll be happy to answer.
Members, are there any questions? Representative Money.
Mr. Chairman, thank you. So are you saying that indecent assault of a child is a second-degree felony
It is.
as well? Okay.
Indecent assault by contact is a second-degree felony.
Okay, thank you.
You're welcome.
Members, any other questions for this witness? Thank you, ma'am.
All right, thank y'all.
Members, anyone else wishing to testify on, for, or against House Bill 2593? See none, invite you to close.
Thank you, Mr. Chair and members. Appreciate your favorable consideration. I close.
Thank you.
Thank you for your time today.
Yeah, I don't know if this bill will be left pending for the committee. 414. That's one we found earlier. Daniel's stuck in today. Chair lays out House Bill 4414 and recognizes Representative Alders to explain the bill. There is a committee substitute. Chair lays out the committee substitute for HB 4414. Is there objection to the adoption of the substitute? Hearing none, the chair lays out the committee substitute and recognizes Representative Alders to explain the substitute.
Thank you, Chairman Louderback and committee members, for the opportunity to present this committee substitute for House Bill 4414. This creates a specific state-level offenses for mail theft-related check fraud and offense for the theft of a mail arrow key. This is companion legislation to Senate Bill 1281 by Senator Parker, which was approved by the Senate in a 29-2 vote. Although mail fraud is often considered a federal issue, the Texas legislature added a state penalty for mail theft in 2019 in an effort to combat porch pirates who targeted packages, which has helped prosecutors with more flexibility in prosecuting these crimes. HB 4414 has a similar goal, aiming to combat the specific theft of checks, also known as negotiable instruments, and arrow keys, which are the master keys that allow access to a block of mailboxes found in neighborhoods, apartments, or businesses. This has become a rising problem in recent years, with the U.S. Financial Crimes Enforcement Network reporting that mail theft-related check fraud amounted to $688 million in just a 7-month period in 2023. HB 4414 will help combat this problem by creating a new state-level penalty structure for the theft of mail that contains a negotiable instrument. Based on the number of checks stolen, this ranges from a state jail felony to a felony of the first degree. It also adds a penalty enhancement to the next higher category of offense if the criminal knew or had reason to know that the victim was a disabled or elderly individual. With respect to arrow keys, HB 4414 creates an offense for the theft of a mail receptacle, key, or lock as a third-degree felony, or on first offense with all subsequent offenses as a second-degree felony. The committee substitute for HB 4414 makes an additional change to help with the enforcement and prosecution of the check theft. It includes a rebuttable presumption that possession of more than 5 pieces of mail to different addresses or 5 negotiable instruments without the consent of the addressee of the mail was held with the intent to commit fraud. There is also a clause that the presumptions do not apply to businesses or agencies engaged in lawful conduct such as mail carrying. Mr. Chairman, committee members, I would be happy to answer any questions you have right now. I know there are a couple witnesses, so I yield for witness testimony. I reserve my right to close.
Members, are there any questions for Representative Alders? Thank you, sir. Chair calls Adam Colby. Now, you show registered as Adam Colby, and who do you represent?
The Texas Financial Crimes Intelligence Center.
And you're on, for, or against the bill?
I'm neutral on this due to my position as the director of the agency. Do we need to correct anything?
No,
No.
represent itself.
Are you going to represent yourself?
As well, yes, sir.
Thank you, sir. Go ahead.
Okay. Chairman Lauterbach, good morning. Representatives, good to see you again. For the record, my name is Adam Colby. I'm the Director and Chief Investigator for the Texas Financial Crimes Intelligence Center. This bill seeks to address one of the fastest growing crimes in Texas and across the country. This is the theft of checks from the U.S. mail and the subsequent forgery and identity theft that follows. Checks or negotiable instruments are stolen in a variety of ways. What we used to see is the individual stealing the mail out of an individual blue box or a residential mailbox to steal one or two checks. This has changed. This method is no longer the way that things are happening. This has become organized crime. We now see many other methods, including gang members, that have been brought into the fold of this and taught how to commit forgeries, often robbing postal carriers at gunpoint, stealing their satchel of mail and the arrow key, which can then be duplicated or used to open any blue box in the zip code. We also are seeing postal employees that are being bribed to steal checks and provide arrow keys directly from the postal facilities. This has become a scourge for Texans who are victimized, as well as the financial institutions and retail establishments that ultimately eat the loss. These checks are often washed and rewritten for a change of payee and amount. One of my own family members had a small check changed to $19,000 in clear. Fortunately, the bank made him whole. Stolen checks are also resold on the dark web, especially business checks, which are mass reproduced and passed all over the country. Current statute addresses the problem from the standpoint of the value of the check, and only when it is passed. This bill seeks to address the problem for what it truly is, the theft of personal identifying information, which is exactly what a check holds. A name along with a unique identifying account number is what constitutes PII under Texas code. Enacted as law, this bill would treat the theft as a negotiable instrument as the theft of personal identifying information as defined in Chapter 32 of the Penal Code. Rather than seeking to charge a defendant based on the value of the check, like the theft statutes that we see in Chapter 31, this will charge based on the number of negotiable instruments stolen, similar to credit cards or other identifying information. This will give the law true teeth and deterrence. Typically, this crime has been the purview of postal inspectors and can be charged federally. However, there are only a handful of inspectors throughout Texas, and additionally, federal prosecutors typically decline to prosecute cases under a certain threshold, typically $500,000 or more is what their threshold is, and federal system rarely carries any substantial penalties for this crime. If you pass this bill into law, it will provide a significant step towards suppressing this crime and protecting Texans and the Texas economy. Thank you for your time. I'm happy to answer any questions.
Members, any questions? Thank you, sir.
Thank you.
Chair calls Kate Decker. Ms. Decker, you're registered as Kate Decker from the Texas Bankers Association.
Yes.
Do you represent yourself?
No, just the Texas Bankers Association.
Texas Bankers. Are you testifying on, for, or against House Bill 4414?
For the bill, Chairman.
Thank you.
Thank you, Mr. Chairman and members. My name is Kate Decker. I'm the Deputy General Counsel for the Texas Bankers Association. And I'm here on behalf of our members to support the committee substitute for House Bill 4414. First, I want to say thank you to Representative Alders for filing this bill to address the growing problem of mail-related check fraud. The FBI recently reported that check fraud reports have doubled from 2021 to 2023. Much of that criminal activity is related to the mail, where criminals are gaining access to checks. Just a couple of examples of this problem in the state from the banking perspective. We had a small East Texas bank report a loss of $42,000 recently when a customer's check was stolen from the post office and altered from $2,000 to $42,000. Another example from the DFW area. A customer had a check stolen from the outgoing mailbox at the local post office, and it was washed from $25 to $2,500. But that police investigation led to a later traffic stop where the bad actor had hundreds of pieces of mail from local residents in his vehicle. The theft of universal mail arrow keys also appears to be a part of this growing crime. Recent reports from the U.S. Postal Service estimated 38,500 incidents in 2022 and 25,000 in just half of 2023. We believe that the enhanced language in this bill would provide more tools for local and state law enforcement to enforce these laws. Mail theft can be targeted on a federal level, but the federal government either cannot or will not act due to smaller amounts or simply more volume to address. We believe local and state law enforcement should have these tools as well. In addition, where the original statute addresses mail theft generally, this bill provides the specific offense for negotiable instruments, checks, with a penalty structure better suited to this type of crime by tying the penalties to the amounts of negotiable instruments stolen rather than numbers of addressees in the stolen mail. The bill also adds a specific offense for the theft of the mail arrow key, providing law enforcement a better and more accurate tool for charging and prosecuting that offense. Thank you for the opportunity to speak with you today. Thank you for your consideration of this bill.
Thank you. Members, any questions? Thank you. Is there anyone else who wishes to testify on, for, or against House Bill 4414? Recognizes Representative Little. If not, the Chair recognizes Representative Alders to close.
Mr. Chairman, committee members, thank you for the opportunity to present this, and I ask for your favorable consideration, and I close.
Thank you. If there is no objection, Chair withdraws the committee substitute for HB 4414. Seeing none, the Chair hears none, and the committee substitute to HB 4414 is left pending.
Or, so just the regular, just say, just House Bill 4414 is left pending.
No HB.
So you withdrew the committee sub, so just say House Bill 4414.
House Bill 4414 is left pending. Which one? Cooks?
No, 1720.
I saw it there. Nope, that's 3167. Kick his ass.
Sarah, I'll go next door.
Okay.
So what number do you want to do? Is she here? What number is it? Chair lays out House Bill 1720 and recognizes Representative Gerben Hawkins to explain the bill.
Thank you, Mr. Chair, members, for hearing this awesome bill this morning. House Bill 1720 is a crucial piece of legislation aimed at protecting facilities that house animals from trespassers by creating a specific criminal offense for trespassing in these facilities. The bill ensures the animals are safeguarded from potential harm and stress caused by unauthorized intrusions. Additionally, it mandates restitution for any property damage resulting from such trespass, thereby holding offenders accountable and providing financial relief to facility owners. HB 1720 not only enhances the security of animal housing facilities, but they also promote responsible behavior and respect for property rights. This bill is a proactive step in addressing a growing and deeply concerning trend across Texas. In recent incidents statewide, there have been many individuals unlawfully entering a cage, enclosure, or other area where an animal is being housed, including zoos. These intruders are disrupting not only the animals' well-being, but also the safety and security of the facility. Great harm can come to both the animals and the people trespassing within the animal areas. Current law does not hold perpetrators criminally responsible for their actions in these cases. In a notable 2023 case, a 24-year-old Dallas man broke into the Dallas Zoo and stole 2 emperor tamarin monkeys. He placed the monkeys into his backpack and made his getaway to the Dallas area rapid transit DART system. Police and investigators found the 2 monkeys in a closet in his apartment. This young man has admitted to stealing multiple animals from the zoo because of his love for animals. However, his actions have placed the animals in extreme danger by exposing them to unfamiliar and unsafe environments and created safety risks for zoo staff, visitors, and the public. HB 1720 would make trespassing in a facility that houses animals a jail felony, becoming a 3rd-degree felony if the person harassed the animal and the animal suffered injury or death. Animals in captivity live in stable environments with minimum human interaction, excluding their zookeepers. Thus, when an unfamiliar person enters their enclosure, it disrupts their routine, causing extreme stress, triggering defensive behavior, and disturbing their psychological well-being. In cases where an animal reacts defensively to an intruder, it is often the animal that faces consequences, such as being labeled aggressive or, in some cases, euthanized. Texas is home to over a dozen zoos, aquariums, and wildlife preserves that serve vital roles in education, conservation, and tourism. Protecting the integrity of these institutions means protecting the animals that live within them and those who care for them. HB 1720 demonstrates a commitment to the safety and security of animals, staff, and visitors at Texas zoos. With that, Mr. Chairman, I would respectfully reserve my right to close, but I do believe there's some witnesses here.
Thank you. Members, any questions? Reverend Hawkins? Representative Money?
My question is why, how did you come up with the punishment scale here, or that it was a state jail felony rather than a misdemeanor or something else like that? The example that you gave of someone stealing animals, I would assume, is already a different crime. I don't know what it would be, but I would assume that that's already something. So just going into the cage, but just wonder what your thought process was, or if you're hearing from zookeepers or something
Hearing
like
from
that.
zookeepers, and one of the things I think is so important, think about a animal that's being raised in a zoo. I mean, they come from the wild. It creates a lot of danger, and right now, because there's no penalty for it, people think it's an open market to be able to take those animals. Those animals cost a lot of money for the zoo, number one. Number two is the concern is if they get out in the general public, we're talking real danger.
Thank you.
Thank you for that question. Any other?
Thank you. Members, any other questions? Thank you. Chair calls Tim Morrow. We show you registered as Tim Morrow,
Yes, sir.
and you represent,
San Antonio Zoo.
and are you testifying for yourself,
Just San Antonio Zoo.
just for the zoo?
Yes, sir.
And on for or against the bill?
4.
Thank
I
you.
agree with Representative Gervin Hawkins. This is an awesome bill.
Thank you. Go ahead.
Chairman Lauerback, members of the committee, thank you so much for your time. My name is Tim Morrow, President and CEO of San Antonio Zoo. Here today to testify in support of House Bill 1720 relating to the creation of criminal offense of trespass in a facility housing an animal and to restitution for that property damage resulting from that trespass. I've spent the last 30 years of my life working in zoological facilities in Texas, and during that time, I have long since lost count of break-ins and inappropriate human behavior in relationship to not respecting rules, barriers, and the well-being of animals in our care. San Antonio Zoo, a 501c3 institution of education and conservation, is home to hundreds of species, many of them endangered and some completely extinct in the wild. We have a great responsibility to educate the public and lead, fund, and participate in conservation programs around the world. Our teams spend their lives caring for and protecting these animals at our facilities and in the wild, and in some cases, San Antonio Zoo is the only place in the world that they exist. We work closely with U.S. Fish and Wildlife, USDA, and Texas Parks and Wildlife, and other organizations to save species from extinctions. Humans breaking into zoos or facilities, crossing barriers into habitats creates a danger for themselves, the staff, and the animals in our care, which could ultimately lead to the death of any of them. Currently, someone crossing barriers, putting lives and well-being of themselves and others at risk, would at most be charged with a trespass Class B misdemeanor. In most cases, police will simply escort the person off property and ask that we issue a private no trespass warning. HB 1720 demonstrates a commitment to the safety and security of animals, staff, and visitors at Texas Zoo, and I ask for your support on this crucial issue and urge the passage of HB 1720. Thank you for your time, and I'm glad to answer any questions as well.
Thank you for your testimony. Members, any questions? Do not. Thank you, sir.
Thank you.
Chair calls Diana Warden. Morning. We show you registered as Diana Warden,
Yes.
representing the Dallas Zoo.
Yes, sir.
You represent yourself,
No, just the Dallas Zoo.
just the Dallas Zoo,
Yes,
on,
sir.
for, or against House Bill.
In support of.
Thank you. Go ahead.
Chairman Louderbeck, members of the committee, my name is Diana Worden, and I'm the Senior Director of Safety and Security at the Dallas Zoo. I'm here today to testify in support of House Bill 1720. In January of 2023, the Dallas Zoo went through an unprecedented series of events that terrorized our facility, our animals, our staff, and our guests. When Davion Irvin repeatedly entered zoo property in the darkness of night and created havoc while on zoo grounds. He caused the intentional release of Nova, one of our clouded leopards. He attempted to steal a langur monkey. He did steal 90 goldfish and 50 crawfish, several otter enrichment items and food, and finally, he stole 2 of our beloved Emperor Tamron monkeys, Bella and Finn. He eluded our security practices every time. And on the night of January 29th, 2023, Davion once again entered the Dallas Zoo by jumping over a fence and breaking into Bella and Finn's night holding. He cut the mesh of their caging, he grabbed them, he shoved them into backpack, and he took them to Lancaster via the DART rail system. During a significant ice storm with below freezing temperatures, he stashed them in an abandoned house with no heat and no electricity. For a tropical species that cannot withstand freezing temperatures, this was a true death sentence for them. Miraculously, and with the help of the Dallas Police Department and the public, we were able to rescue Bella and Finn the night after they disappeared. While they lost a significant amount of body weight for their little frames, they did escape with mostly minor lacerations. Unfortunately, Davion was not at the house at the time and once again eluded arrest. A few days later, our colleagues at the Dallas World Aquarium recognized Mr. Irvin on their campus attempting to do the same thing. He was apprehended as he left their facility and ultimately charged with 6 counts of misdemeanor animal cruelty and 2 felony theft charges, all stemming from his escapades at the Dallas Zoo. Davion confessed to the crimes but was found incompetent to stand trial. He spent the next 2 years at a state hospital in East Texas. However, in February of 2025, his competency was restored, which also happened to coincide with his statutory timeout period. He was released in early March of this year, and because he never stood trial, all his charges were dismissed with time served. At the time of his arrest in 2023, Mr. Irvin told detectives that he would come back to the zoo and take more animals if he could. Today, we are confident in the security upgrades we have made and have one of the most advanced security systems of any zoo in the country. However, having more protections in place for our facility and allowing for restitution owed would make us and the guests feel more secure and comfortable as we continue our mission of engaging people and saving wildlife.
Thank you.
Thank you.
Members, any questions for Ms. Warden? No, thank you.
Thank you.
The chair calls Eric Traeger. Morning. We show you registered as Eric Traeger,
Yes.
Animal World and Snake Farm Zoo.
Yes, sir.
Okay. Are you on, for, or against House Bill 1720?
I am for House Bill
Thank you.
20.
Go ahead.
All right. Good morning, Chairman Louderback, members of the House and Criminal Jurisprudence Committee. My name is Eric Traeger. owner of Animal World and Snake Farm Zoo in New Braunfels, Texas. Many of you probably have heard of it as the Snake Farm, where we've protected exotic animals for over 50 years. I strongly support House Bill 1720, which makes trespassing in animal housing facilities a state jail felony, escalating it to a third-degree felony if animals are harmed, and mandates restitution. In today's social media era, the pursuit of viral fame or profit drives trespassing into zoos for selfies or videos with dangerous animals. We must act now to prevent this. We've heard in 2023 the Dallas Zoo faced trespassing, and so I'm not going to go into those details as I originally planned. But I'd like to bring up a recent situation that happened at our zoo where a woman jumped our barrier fence because she wanted to pet a lion on video. She went around to an area that she could pet it. Fortunately, we have staff watching these areas, and we were able to intervene before this occurred. This was all for, you know, a YouTube video or something like that. When the police came, as said earlier, she was just escorted from the property, and we were asked to just, ask her not to trespass. At our zoo, we invest heavily to secure venomous snakes and big cats, yet these risks grow. House Bill 1720's felony penalties deter reckless trespassing before it escalates, ensuring accountability. Representative Lauterbach, your sheriff experience highlights the urgency of protecting Texas zoos. I urge the committee to pass House Bill 1720 to safeguard our animals, staff, and communities. And I appreciate your time. Thank you.
Thank you. Members, any questions? Appreciate you. Thanks. Chair calls Erica Boyd. We show you registered as Erica Boyd
Yes, sir.
of Texas Travel Alliance.
Yes, sir.
And are you on for or against the House Bill
For the bill.
1720? For the bill.
Yes,
Thank
sir.
you. Go ahead.
Good morning. Excuse me. Good morning, Chairman Lauterbach and members of the committee. My name is Erica Boyd, President and CEO of the Texas Travel Alliance. I'm here today to testify in support of House Bill 1720. Texas Travel Alliance represents businesses across Texas in travel and tourism, hotels, attractions, zoos and aquariums, and many more businesses who help strengthen the Texas economy and support over 1.3 million jobs in Texas. We have an economic impact of over $193 billion to the Texas economy and generate over $9 billion in state and local tax revenues for our communities. We believe that House Bill 1720 is a crucial piece of legislation aimed at protecting facilities housing animals from trespassers. By creating a specific criminal offense for trespassing in these facilities, the bill ensures that animals are safeguarded from potential harm and stress caused by unauthorized intrusions. As you've heard about these break-ins at zoos across Texas, this is an alarming trend that we believe this legislation can help to stem the tide of. We thank Representative Gerben Hawkins for filing this important legislation, and we thank you for your time this morning and favorable consideration of House Bill 1720.
Thank you. Members, any questions? Ms. Boyd? I've seen that. Thank you very much. Let's see, no more. Is there anyone else who wishes to testify on, for, or against House Bill 1720? If not, the chair recognizes Representative Gerben Hawkins to close on the bill.
Thank you, Mr. Chair. Members, I'm one who's truly not one who wants to escalate criminal offenses. But we have to think about the danger that's being created. And we have to be able to put those stop gaps in, because there are people now who want to make headlines and they want to go into these areas, get these animals, and what they could do to the community could be devastating. So I really appreciate your support for this bill, trying to deter people from stepping into something they don't quite understand and or creating danger to themselves and to the community. Because as you well know, if something happens devastating and someone dies in a zoo, that almost really destroys that zoo and prohibit people from coming. And that's why this is so important. And with that, Mr. Chair, I would be happy to answer any questions, or if not, I'll close.
Thank you, Representative.
Thank you.
If there's no objection, the bill will be left pending. There is none. The chair hears none. And HB 1720 is left pending. Let me find that somewhere. We're going to do 3425, right? Who's that? We need to do codes. The chair lays out House Bill 3425 and recognizes Representative Capriglione to explain the bill.
Thank you. Speaker Moody, members, in a time when our lives are increasingly lived online, the threats we face have also gone digital. House Bill 3425 is a common sense bill that strengthens our state's ability to protect Texans from targeted harassment and intimidation in the digital space. While we took an important step last session by passing House Bill 611, which made it a crime to publicly share someone's address or phone number online with the intent to do harm, that statute only applied to disclosures posted on internet websites. It doesn't address disclosures made through other common digital tools like text messages, emails, or social media platforms. This bill ensures that malicious disclosures, what we commonly call doxing, are treated the same regardless how the information is shared. House Bill 3425 updates the penal code to include electronic communications as a method of unlawful disclosure. This could be by email, instant message, text, social media platforms or apps, internet-based communication tools, and even older tools like fax machines. Bad actors are using every tool available to harass and endanger others, and our laws must keep pace. Speaker, I appreciate the interim hearing you held that included a lot of conversation about the doxing bill that we had passed in your committee last session. Appreciated the comments, and as this bill is kind of the continuation of that, we saw in campaigns and all over, even in the public life, that malicious actors are just doing everything they can with evil intent to harm others, but they're not doing it just on websites. They're doing it with text messages and other forms. So with that, happy to answer any questions.
Questions for Chair Capriglione? Representative Moody.
Thank you, Mr. Chairman. No questions. Just appreciate you following up on the work. I know during the interim, the recommendations were to do exactly this. There's some other things we can still do around doxing. It's going to be an evolving statute over the years because people are going to continue to evolve the way that they commit this crime. So I appreciate you trying to stay on top of it for everybody. Thank you.
Thank you.
Thank you. Is there anyone who wishes to testify on for or against House Bill 3425? Not the chair recognizes Chairman Capriglione to close on the bill.
I close.
Thank you. Thank you, Representative. If there is no objection, the bill will be left pending. Chair hears none on HB 3425 is left pending. Chair lays out Senate Bill 20, and Chair Capriglione to explain the bill.
Great. Thank you again, Mr. Speaker, members. As technology advances, so too do the tactics used by those who seek to exploit it for immoral purposes. This is Senate Bill 20, and what I wanted to point out is that a particularly concerning development is the creation and distribution of AI-generated, animated, or computer-generated images that appear to depict minors engaged in sexual conduct. While no real children may be involved in the production of such material, the images are often indistinguishable from actual child pornography and can be just as harmful to public safety and community values. Under current Texas law, our ability to prosecute these offenses is limited. Existing statutes primarily address images involving real children, leaving a dangerous gap when it comes to digital fabrications. This legal blind spot has made it difficult for prosecutors and law enforcement to hold individuals accountable for possessing or promoting these materials, especially as they continue to proliferate online. Senate Bill 20 closes this gap by expanding the definition of obscene visual material to include AI-generated images and other synthetic depictions that appear to involve children. It establishes clear criminal penalties for those who knowingly possess or promote such content, regardless whether the images are digitally fabricated. The bill sets the offense as a state jail felony with enhanced penalties for repeat offenders, a third-degree felony for those with one prior conviction, and a second-degree felony with those with two or more. Additionally, Senate Bill 20 amends the penal code to include this offense under organized criminal activity, giving prosecutors expanded tools to pursue coordinated operations trafficking in these materials. This legislation ensures that Texas remains at the forefront of child protection by acknowledging the real-world dangers of digital exploitation. We must act decisively to ensure that our laws reflect the evolving technological landscape and leave no room for the exploitation of minors, real or perceived.
Thank you. Members, any questions? The chair calls Grayson G.
Reserve the right to close.
Thank you, sir. You show you registered as Grayson G.,
Yes, sir.
representing the Texas Public Policy Foundation,
Correct.
and you're on, for, or against?
On.
House-
Or
Senate Bill
in
20.
favor. For.
In favor of. Thank you.
Yeah.
Go ahead.
Good morning, Chairman and members of the committee, subcommittee. Thank you for the opportunity to speak today in support of Senate Bill 20. My name is Grayson Gee, and I'm a tech policy analyst with the Texas Public Policy Foundation. The fundamental issue before the subcommittee today is the protection of our children in an increasingly digital world. While artificial intelligence itself is not new, recent technological advances have created unprecedented challenges. The convergence of increasing computing power, decreased costs, and user-friendly applications has allowed AI to become widespread, including, unfortunately, the creation of AI-generated child exploitation material. To understand the gravity of this situation, I wanted to share just a few sobering statistics. 98% of all deepfake videos online are pornographic, with 99% of individuals targeted being female. Since 2016, the number of web links containing child exploitation has doubled every 15 months. The National Center for Missing and Exploited Children received 4,700 reports of generative AI pornographic images in 2023 alone. And due to the complicating factors of reporting, these numbers likely underrepresent the actual scale of the problem. SB 20 provides crucial clarity to address the possession, access, and promotion of AI-generated child exploitation material. The provision, regardless of whether the depiction is an image of an actual child, is particularly important in the bill as it captures content that blends features of different children or even creates fictional children out of whole cloth. The bill represents a balanced approach that protects children while addressing the unique challenges presented by AI technology. Whether fake or otherwise, this bill provides meaningful tools to law enforcement. Thank you for the opportunity to testify today, and I look forward to any questions you may have.
Thank you. Members' questions? See none. Thank you.
Thank you.
Is there anyone else who wishes to testify on, for, or against Senate Bill 20? Not, the chair recognizes Chairman Cabriglione to close on the bill.
Thank you. I'd like to thank Lieutenant Governor Dan Patrick for making this law a priority of his in the Senate. I want to thank Senator Flores for all the work he's done. I want to thank TPPF and Grayson and others for being supporters. Make sure that we prevent and ban the exploitation of our children with the use of artificial intelligence or any technology. With that, I close.
Thank you, Representative. If there's no objection, the bill will be left pending. Chair hears none. Senate Bill 20 is left pending. Chair lays out House Bill 3061 and recognizes Chairman Oliverson to explain the bill.
Thank you, Chairman Lauterbach and committee members, Representative Moody. House Bill 3061 is a pretty straightforward bill that addresses, I think, something that we've all seen happen more commonly, which is folks gather at a demonstration, the demonstration turns violent or destructive. People are wearing masks with the intent to conceal their identity and, commit criminal acts and then disappear into the crowd. So essentially, what this bill does is it would allow a district attorney to pursue an enhanced criminal penalty under very certain and very tightly controlled circumstances. The circumstances are, first of all, the individual would have to be at some type of demonstration or gathering. They would have to be separately charged with committing a crime while they were there, and we have the list of crimes. This isn't something where someone's going to get randomly profiled or anything like that. This is things like arson, trafficking human beings, sex offenses, assaulting a police officer, arson, destruction of property, things that would be pretty obvious criminal offenses to begin with. And then if they, while committing that crime at that gathering, are also wearing a mask for the purposes of concealing the identity, and I should emphasize the burden's on the state to prove that they weren't wearing a mask for other reasons, such as health-related reasons. There's even specific language in the bill dealing with a situation where an individual might be on their way to a masquerade party or it's Halloween. So, this is very thoughtful in terms of making sure that there are exemptions for folks that might be wearing a mask for a legitimate reason. But in the event that they are at a riot, committing a crime, and wearing a mask for the purpose of concealing their identity, it would allow the district attorney the option, not the mandate, but the option to pursue an enhanced criminal penalty. And that's essentially what it does. I want to be clear, this bill is not about prohibiting masks. I get that question a lot. It doesn't do that. It doesn't say that anywhere in the bill. And it also doesn't create a scenario where somebody who's just going about their business at the grocery store wearing a mask is going to be arrested and charged because they're not creating a criminal offense, which is a precursor for this law even being triggered. So that's what it does, and I'm happy to take any questions, and I'd like to reserve my right to close.
Thank you. Members, any questions for Representative Oliver? Thank you, sir. Chair calls Charlotte Friend. Ms. Friend, you show you representing yourself?
Yes, sir.
Okay. And you are testifying on, for, or against? House Bill
Against.
3061?
Yes, sir. Against 3061.
Thank you. Go ahead.
Members of the subcommittee and Chair Louderback, my name is Charlotte Friend. I'm an immunocompromised Texan who is in opposition of House Bill 3061 on the basis of medical, financial, and constitutional rights of the good folks of Texas. Firstly, there are no medical exemptions written into this bill, which I believe is a huge oversight underpinning the other points I have to make. There are exemptions for Halloween and other celebrations, but not medical necessity. Secondly, I would like the subcommittee members to take heed of the fiscal note and seriously ask yourselves if this is the best way to spend the hard-earned tax dollars of your constituents. It would only take 316 individuals to be held in an adult system-wide facility for 1 year to cost Texans $10 million. Considering research shows sunglasses conceal identities more effectively than masks, on top of the immense software developed to identify citizens, one could reasonably conclude that implementing this bill would be a drain on the budget. Lastly, for the record, Representative Little was added as an author to this bill on April 3rd, just over a week after stating publicly on social media that he, quote, hopes to ban protesters from concealing their identities using masks, end quote. From this comment, the intent of criminality is presumed. I have asked both authors to clarify this stance as well as to point me to where in the bill and its related codes protests are explicitly mentioned. The only response I received was from Representative Little, and it disregarded my questions. So I'm asking here and now how the members of the House of Representatives will ensure that Texans' First Amendment right to freedom of expression and assembly are not curtailed by House Bill 3061. It should not be a controversial stance to write in an email, ask a staffer to relay over the phone, or have it on record in a public hearing. Thank you.
Thank you. Members, any questions? Representative Little.
Ms. Friend, over the weekend in Frisco, Texas, there were a couple of Antifa members who were arrested trying to cause a race riot in what is an otherwise peaceful community. I guess they were immunocompromised too, because both of them were wearing masks. Why do you think it is, just a question for you, why do you think it is that so many Antifa members are immunocompromised?
You know,
Is it like
Okay.
are they a specific vector for disease? That every
Sir?
time they show up and try to create a riot, that they need to wear a mask? Are they
Representative Little-
particularly susceptible to communicable diseases, do you think?
Representative Little, first and foremost, I'm not a doctor. Second of all, masks help prevent the spread of disease. And that's all I'm going to say on that.
Well, the author is a doctor. I'm not a doctor either. But it just seems to me that a lot of people that incite riots in major cities and even small suburbs like Frisco, Texas, where I work, are very concerned with spreading communicable disease. Why do you think that there's such an overlay of people who want to cause violent trouble in the course of protests being super concerned about spreading disease?
I don't have an answer for that, and may I ask Representative Little a question in response?
Go ahead.
Do you or do you not support the First Amendment rights of Texans? I've asked you multiple times, and you've never once responded to me.
Of course I do. Do you think the First
Okay.
Amendment
Please
extends?
keep your remarks to the bill.
Sure. Thank you, Chairman Louderback. Of course I support the First Amendment rights of Texans. Do you believe you have a First Amendment right to wear a mask when you're creating a race riot? Yes or no?
Is that part of this bill?
It absolutely is. Do you think you have a First Amendment right to wear a mask when you're inciting a race riot? Yes or no?
I don't want to answer that question.
I didn't think so.
Because of the law of large numbers. When large groups of people get together, we see how arrests are made, and we
Thank you.
see
One
how
question.
individuals. Yes, sir.
Do you see where sunglasses, a hoodie, or a mask could be used to block or inhibit someone's identity in any kind of criminal affair?
That's already
do you
occurring.
see that?
That's already occurring, and in many situations, the penalty reflects that
All right, thank
already.
you. Any other questions for this witness? Thank you.
Thank you very much.
Charles Tom Glass. Mr. Glass, you show registered as Tom Glass in the Texas Constitutional Enforcement, and you also show yourself.
Correct.
And you're testifying on for or against House Bill 3061?
We are in favor of the bill.
Thank you, sir. Go ahead.
Thank you. I believe that every Texan has the right to protest, to speech, and to assemble. What they don't have the right to do is engage in criminal acts in the name of protest or assembly. And that includes you don't have the right to stop. Already in our riot laws today, it says you can't impede people going about their day-to-day business. It says you can't destroy property. It says you can't threaten or harm individuals. And so those are criminal acts, and they need. We know in the law already that there's a big difference between engaging in criminal acts and trying to raise attention about what your position is on a particular issue. And so I do know the reason why I chose on the behalf of the organization to come talk about this bill is I do know that there's people who are hostile, the people most hostile to our Constitution today, which I would include Antifa, and I would include some of the people that have been doing the anti-Semitic and anti-Israel protest in our things, hate America and hate our Constitution. And if they want to try to claim that the Constitution protects them in these acts, I don't think they have a legitimate leg to stand on. And so I believe we do need to do as much as we can to make sure we discourage the violent acts in the name of protest, and while maintaining respect for the rights of people to protest.
Thank you.
Thank you.
Any questions to this witness? Thanks, sir. Chair calls Cole Glosser. Mr. Glosser, we show you registered as Cole Glosser with the Coalition of Texans with Disabilities.
That is correct.
And you're on for or against House Bill 3061
I am on, sir.
on the bill.
Yes.
Thank you. Go ahead.
Honorable Chair Lauterbach and members of the committee, thank you so much for the opportunity to testify here today. Hello, my name is Cole Glosser, and I'm a policy fellow with the Coalition of Texans with Disabilities, an organization advocating for people with disabilities to live freely and thrive in the community of their choice. And I'm testifying on HB 3061, and I want to share my concerns on how increasing criminal penalties while masking would impact the disabled community. There are thousands of disabled Texans and family members who need to mask due to chronic illness or being immunocompromised in order to protect their health. Masking has become an incredibly important tool for those who are immunocompromised to protect their health in public settings, and it's crucial that they are able to continue to do so now and in the future. We want to ensure that any measure taken acknowledges that the particular vulnerable position this population faces due to potentially unforeseen consequences and attitudes towards masking. Those who are chronically ill and immunocompromised deserve every right to their health and safety while also having their privacy respected in public. Law enforcement officers may not know that the reason an individual might be masking is to protect their health, the health of a vulnerable family member. And masking for immunocompromised people becomes stigmatized because of penalties. They will feel less comfortable to mask, and there will become an increased chance for these individuals to be exposed to viruses and infections that their bodies will have an incredibly difficult time fighting, and they'll be further isolated from public life. Health is a safety issue. We also risk those who have chronic conditions in the disability community, such as those undergoing chemotherapy or have respiratory illnesses, to, for example, not find safety in public due to the fear of exposure impacting their health. We also want to highlight that while there is currently a defense in the bill at trial for a Halloween or masquerade ball mask, which would not increase the punishment, there's currently no defense protecting one's health against illness. Thanks so much.
Thank you. Members, any questions? Thanks, sir.
Thanks so much.
Chair calls Susanna Carranza. Chair calls Susanna Carranza. Chair calls Kirsten Budwine. We show you registered as Kirsten Budwine of the Texas Civil Rights Project.
Yes,
You're-
sir.
And you're on for or against House Bill 3061?
Against the bill.
I'm sorry?
Against the bill. For,
Against-
yeah.
Against the bill?
Yes, sir.
Okay, good to go. Thank you. Go ahead.
Dear Chairman and members of the committee, my name is Kirsten Budwine. I'm here as a policy attorney with the Texas Civil Rights Project in opposition to HB 3061. Peaceful protesters are often charged with the offenses listed in this bill, including riot, and are highly likely to be targets of this bill. Imposing a mask ban, especially in the context of exercising the right to protest, will likely impede on Texans' right to anonymously protest. The U.S. Supreme Court has affirmed the right to anonymously political expression and association in several cases. In one of those cases, McIntyre v. Ohio Elections Commission, the court highlights the importance of preserving this right, stating, quote, "Anonymity is a shield from the tyranny of the majority. It thus exemplifies the purpose behind the First Amendment, in particular, to protect unpopular individuals from retaliation and their ideas from suppression at the hands of an intolerant society." The court's rationale in this case still holds true today. In this day and age where doxing is at an all-time high, people are receiving death threats, experiencing harassment, being terminated from their jobs, and even being deported for their political beliefs, it is imperative that protesters are free to protect themselves from retaliation. U.S. district courts have recognized mask wearing during demonstrations as symbolic speech protected by the First Amendment. In Arian v. Mackey, student organizers sued Texas Tech University after the university agreed to grant them a permit to hold a peaceful demonstration only if the student organizers agreed not to wear masks. Texas Tech argued that anonymity via mask would encourage demonstrators to engage in violent activity. The court sided with the students, holding that masks served a communicative purpose and were therefore protected under the First Amendment as a right of freedom of expression. I don't know if that was my time, so I'll stop there.
Thank you.
Thank you.
Members, any questions? Thank you.
Thank you.
Chair calls Naveen Farani. We show you registered as Naveen Farani,
That is correct.
testifying as yourself, and against the bill, House Bill 3061, is that correct?
That is correct.
Thank you, go ahead.
Okay. Good morning, Chairman Louderback and committee members. My name is Naveen Farani, and I am testifying against House Bill 3061. My primary concern with this bill is the implications on public health and the spread of disease. Something Rep. Oliverson mentioned when laying out the bill is that this bill is concerned with what should be considered obvious crimes. We have a First Amendment right to protest and to protest anonymously. And this bill presumes criminality. When a group of people is gathered together, when it changes from 6 people to 7 people, that's the line of what can be considered a riot. But in this charged political climate, the difference between a group of people peacefully protesting, exercising their First Amendment rights, and participating in a riot is a matter of someone's opinion based on whether they agree with the group of demonstrators or not. There is a big subjective difference in who gets a slap on the wrist, who gets more severe punishments when riots are concerned. When there are currently more than 800 measles cases across the country, the majority of them in the state, dissuading people from wearing masks when gathered in groups, regardless of reason, is a direct threat to public health. In conclusion, I urge you all to please reconsider this bill and the impact it will have on disabled and immunocompromised people and the well-being of Texans in general. Thank you.
Thank you. Members, any questions?
Real quick, Chairman.
Representative Little.
Isn't it true that you wear a mask when you go to protest because you don't want to bear the social consequences of having been at the protest? Isn't that why you wear a mask?
No, I wear a mask primarily because when I'm in a big group of people and when I'm indoors in public spaces, I am trying not to contract communicable diseases. My spouse is immunocompromised, so even if it doesn't have a direct impact on me, if I bring something home, I would not forgive myself if I got my partner further sick.
What about outdoor spaces?
Communicable diseases can still be spread outdoors.
Yeah. Have you ever been to a protest before?
Yes, I have.
Did you wear a mask?
I do.
And you did that because you're immunocompromised?
Because my spouse is immunocompromised,
Okay.
yes.
Well, where do you work?
I work at Equality Texas.
Okay, and what does Equality Texas do?
It is an LGBTQ advocacy organization.
Okay. Do you work anywhere else?
Nope.
Are you a student?
Nope.
Have you assaulted a police officer at a protest?
No, I have not.
Okay. Do you think that someone who assaults a police officer at a protest and is trying to conceal their identity through a mask, do you think that they should be treated differently?
Not necessarily, no.
Do you think that someone who obstructs justice at a protest and is wearing a mask should be treated differently from someone who does not?
No.
Okay. Thanks.
Thank you.
Thank you. Is anyone else who wishes to testify on for or against House Bill 3061? If not, the chair recognizes Chairman Oliverson to close on the bill.
Thank you, Mr. Chairman and committee members. Just in closing, I just want to say again, this is only applicable in a situation where somebody is already accused of having committed a criminal act. So all of these other circumstances where one might be wearing a mask, it is not an issue for them because this would not apply. I want to thank my 55 co-authors and especially my joint author, Representative Little. I ask for your favorable consideration and I close.
Thank you.
Mr. Chairman.
Representative.
No question, just a comment. I mean, I do understand what you're trying to get at here. But I think you got to balance. I mean, right, there's obviously concerns that are raised, but under the like, what's baked into the cake of criminality is that criminals want to evade prosecution. They want to evade being caught, right? So the concept of someone trying to get away with it or trying to make themselves, more difficult to catch, like that's baked into the criminality. So we deal with that in penalty ranges. And so when I look at riot, just specifically that statute, you have a base level offense that's a class B. And so, and then that base level offense can raise up. So if there's an assault on a peace officer, that riot offense raises up with that alongside it. So it drags up with the higher level offense that goes on in the riot, the level of criminality of the riot goes up too. So you have multiple charges tracking with it. That's how we've handled this stuff. I mean, there's also criminal mischief, all sorts of other things you can do in an environment like what you're talking about, when protests turn violent. That's where we usually house these types of penalty, increases. And so I would encourage you to look at those statutes because they have ratchet up potential baked into them now. And I think when you start looking at someone is trying to evade or elude or whatever, I mean, those are all parts of every single offense. And so nobody wants to get caught for what they want to do. So I think what you do, philosophically, I understand where you're trying to go. I think that conversation is better housed in creating increases in penalties within the statutes that we have now rather than adding this provision. That would just be my concern. So, but I do understand what you're trying to get to.
Thank you, Speaker Moody. I appreciate it. Thank you, members.
Thank you, Mr. Chairman, and thank you, Representative Alderson. Does your bill handle exceptions for cultural or celebratory mask use?
Well, I think it talks about, it definitely talks about masquerades and holiday events and things like that. And
section
Representative, if you think that there's some clarifying language on that it's certainly not the intent to catch somebody unintentionally. But again, I emphasize the fact that none of this is even applicable unless you're already committing a crime with a group of people.
Okay, thank you.
And to Speaker Moody's point, I mean, I think that the thing that I see as sort of a slight fundamental difference is I think that, yes, criminals generally try to conceal their identity. And so I think of somebody robbing a bank or a stagecoach, if we were still back in the 19th century, I think there were some funny comments made during COVID about that. But that is different than what we see in this day and age where people are literally videoing themselves setting police stations on fire while concealing their identities and posting it to social media in an attempt to convince others to do the same. And so I think that's part of what we're trying to get at here is that our society, from a criminal standpoint, it's not just committing a criminal act, it's committing a criminal act in a group of people with the intent of concealing your identity for purpose above and beyond that. So we're just trying to create another tool. Again, it's discretionary. The DA doesn't have to pursue it. And I have to think there are probably some urban counties, realistically members where they probably wouldn't, right? I mean, I think we could all agree to that. But I think it's a useful tool in the toolbox for a DA.
All right, and so thank you for your answer. And do you believe that there should be any clearer protections added for religious, medical, or cultural masking?
I'm happy to work with you on those things. Again, I think the fact that you have to be committing a crime in order for this to even be applicable raises the standard pretty high.
Yes.
But if you think something above and beyond that is needed, I'm happy to visit with you about it.
I would love to, and okay. I did write down what you said about already committing a crime, and I do like that you stress that. I just think that you would probably agree that there are still people, even as we've moved through COVID, that still need to protect themselves.
Totally.
I have pre-existing conditions myself, and I probably don't mask up as much as I feel like I need to, but I do get on a flight and I'm like, oh, maybe I should. So I just think that, I'd love to talk to you about it and hear your thoughts on it.
Yes, ma'am. I appreciate you. Thank you.
Mm-hmm.
Thank you, Representative Little.
Yeah,
Thank you, Chairman. I mean, Tom, you wear masks in your profession, right?
I do in the operating room.
I mean, there are lots of good reasons to wear masks if you're sick
Absolutely.
or to protect others from being sick, but it seems to me that the thrust of your bill is to make sure that people are not committing a crime, an additional crime wearing masks or doing something unruly. For example, the situations that we had at UT or even in Frisco this last weekend.
Yes, sir.
I mean, is that what it's getting at?
It is getting at that,
Okay.
yes, sir.
All right, thanks.
Thank you,
Thanks,
Chairman.
sir.
Thank you, members.
Appreciate it. If there's no objection, the bill will be left pending. Hearing none, HB 3061 is left pending. The chair moves that the committee stand in recess until final adjournment, recess of the House, or during bill referral if permission is granted. If there is objection, hearing none, the motion prevails. Committee stands in recess.